Hi there. Thanks for watching this video. My name is Malini Vijaykumar. I'm a partner in the Employment and Labor Law group here at Nelligan Law. If you're watching this, it's probably because you or someone you know has been recently terminated by Bell or one of its affiliates in the group termination that is happening now in fall 2025. I'm sorry that you're going through this. This can be a very stressful time with a lot of information to take in and a lot of choices to make. The point of this video is to try and equip you to be better informed about those choices and to give you a sense of what your rights actually are. So let's dive into it. The first thing that I want to talk about is what your entitlements actually are on termination. So you hear a lot of talk about severance and am I getting the right amount of severance? Am I entitled to more? And you might be wondering, well, how do I know how much severance I'm entitled to? Well, there are three sources of rights in Canadian law that dictate what amount of severance you're entitled to when you're let go from your job. The first source of rights that applies to you as federally regulated employees is the Canada Labour Code. The second source of rights, which may or may not apply to all of you, is what's written in your employment contracts about termination. And the third source of rights is something we call the common law, which is basically judge-made case law through different case decisions. And when we put these three sources together for any given person, we are able to estimate what they would be entitled to if they're let go. So let's talk about the Canada Labour Code first. Because you work for a national telecommunications company, your employment is regulated by this national statute, the Canada Labour Code, not by provincial statutes like the Employment Standards Act of Ontario or something like that. So in the Canada Labour Code, there is a requirement about minimum notice that should be given when someone is let go. And there's a requirement about minimum severance as well as payment of earned wages. So we'll talk about the last one first. Payment of earned wages means that you are entitled to all the pay that you've earned as of your last day of work. So this includes obviously salary. If you are a commission employee and you have commissions that are actually due and payable, so not in the pipeline, but actually due and payable, those should be paid out to you as well. And vacation pay. So for any vacation days that you've earned but not taken, that needs to be paid out to you as well as of your last day of employment. It typically shows up in the next pay period after that. So those are just what you're owed as of your very last day. Then we get into minimal notice and severance requirements. And so while I'm using two different words, notice and severance, they can both be paid out as sums of money, or sometimes the notice period is given as actual working notice, while the severance is always paid out as a lump sum. And these are, again, just minimal entitlements under the Canada Labour Code. The Canada Labour Code provides what we call your floor of protection. So the employer cannot go below this floor, and they cannot, importantly, they cannot ask you to sign any kind of release or agreement in exchange for getting these entitlements. Whatever you're entitled to under the Canada Labour Code, you get unconditionally. So, notice. If your termination counts as a group termination, you may be entitled to all the way up to 16 weeks of notice of termination. This could be given as working notice, or it could potentially be given as pay in lieu of such notice. But importantly, all of your benefits, so health, dental, disability, any pension, any car allowance, anything like that needs to be continued throughout this entire working notice period. Now, if the numbers of terminations haven't hit the group threshold for 16 weeks or requiring 16 weeks notice, you're still entitled to a certain number of weeks of this kind of notice. It depends on your years of service with the company. So it's typically a minimum of 2 weeks up to a maximum of 8 weeks and around 1 week per year of service that you've been there. So if you've been there for 5 years, typically your notice entitlement is 5 weeks, unless 50 or more employees have been let go in a 4-week period, in which case that can go up to 16 weeks. But whatever this minimal entitlement is, it does form part and parcel of your overall entitlements on termination. And finally, in terms of Canada Labour Code amounts, statutory severance. Now, statutory severance under the code is not that much. It's typically a minimum of about 5 days of pay, and or it can go up by essentially 2 days of wages per year of service. So again, taking the example of 5 years, if you've worked there for 5 years, your Canada Labor Code severance pay is about 10 days of pay. So these are relatively small amounts. And if you are getting a termination letter, you should see them described somewhere in the letter as amounts that will be provided to you unconditionally, so without the need to sign a release. If you do talk to a lawyer or decide to engage in negotiations with the company on your own, there can be an ability to tax shelter some of this amount, so to direct it to your RRSP without deduction. That's something that might be of interest to you, given that we're getting close to the end of the tax year. But these are amounts that are paid to you without the need to sign a release. So that's the Canada Labor Code. I'm going to talk briefly now about contractual entitlements. This may not apply to most of you. Employment contracts typically don't talk about above CLC or above Canada Labor Code amounts unless you are in some sort of executive or senior role. So take a look at your contract, see what it says. It might include some sort of severance formula. For example, if you're terminated, you'll get the greater of your Canada Labor Code minimum entitlements, or 3 weeks per year of service paid out as base salary or something like that. Your contract may very well not include this, but it's worth taking a look to see if it does. The important thing to keep in mind, though, is that your contract, even if it does say something like this, even if it does describe what you're intended to receive on termination, that might not actually be binding. The law in this area changes all the time. Courts are always releasing new decisions about what can or cannot be written into contracts about these types of amounts. And so it's very possible, especially if you've been at the company for a long time, that your contractual wording may not be valid anymore. And that is almost always to your benefit, not the company's, because if your contract is no longer valid, that means you get to access what is typically the most generous source of protection, which is common law severance. And so the main takeaway here when it comes to your contract wording is don't take it at face value. Even if your contract says you get X dollars at termination, and even if that's what you've been offered in the termination letter, it's still worth getting a second opinion as to whether you're leaving money on the table because of contract unenforceability. So the third source of protections on termination is what we call the common law or judge-made case law. And there is a rule of thumb in Canadian case law that if you have been terminated without cause, and I should note that this video is only about without cause termination, if you have been terminated with cause, feel free to contact us. That's a very different kind of situation, and we can help you out there. But on a without cause termination, Canadian judge-made common law says that typically you are entitled to 1 month of pay, and that's full compensation for each year that you've been with the company. And this can be elongated if you are in your 60s or older. It can also be elongated if you had a very senior position, if you were managerial, if you had direct reports reporting to you. Conversely, it can be shorter if you are a younger employee, if you have shorter service with the company, or if you're in a position that where it will be very easy to get a replacement job. So, but typically around the rule of thumb is around 1 month per year of service. Now, you will never settle out at exactly 1 month per year of service with the company because of something called the duty to mitigate. So, although common law has this very generous length of default protection, it also comes with the duty to mitigate, which is the duty to try and offset your losses from termination by searching for new comparable employment. So Essentially, what common law does is it provides it, or it is intended to provide a bridge from the end of one job to the start of the next comparable job. And the length of this bridge is typically assessed at around 1 month for every year that you were in the prior job, maybe elongated or shortened due to the factors that I mentioned before. But that can be offset by the likelihood of you getting a new job within that time period. So let's take an example. Let's say you've been with the company for 10 years. So your Canada Labor Code entitlements, which form part of the whole, are about, let's say, 8 weeks of notice. You get about 20 days of Canada Labor Code severance pay on top of that. So you're looking at roughly, you've gotten about just under 3 months paid to you unconditionally without having to sign a release upon termination of employment. Let's say that you have no valid contractual wording that would limit your entitlements or define them on termination. So you are what we call a common law employee. And let's say that your overall entitlement would be maybe 12 months at common law because you've worked there for 10 years, but perhaps you're in your 60s or you were a manager, you're going to find it a little bit harder to get a comparable new job. So let's say your entire entitlement is 12 months. About 3 months of that have already been paid as Canada Labor Code minimums, and you're trying to negotiate with the company as to the rest of it. Maybe they've offered you something like 6 months total on the table, inclusive of Canada Labor Code, and you'd like to push that up a bit more towards the 12-month ceiling. So let's say you're negotiating with a company and, 3 months down the line, you get a job offer. Now, the job offer is for a job that's not comparable to your prior position. It's maybe at a significant pay cut, doesn't have anywhere near the same kind of responsibilities. You decide not to take it. That's fine. You don't have to take a job offer that's not comparable. However, let's say that soon after that, you receive a job offer that is comparable. It's around the same amount of salary, same kind of compensation, similar kinds of duties, and you do accept it. That would mean that you have essentially mitigated yourself out of the remainder of the severance period. So the company's only obligation to you then is to cover the period of time from when you were let go to when you got this comparable new job. And let's say that's at 4 months. So even though you were a 10-month employee or a 10-year employee at Bell, maybe your severance entitlement in this case is only actually 4 months because you have mitigated your own losses. You have picked yourself back up and put yourself back in the same or a comparable position. So, to account for the possibility of that happening, because in most cases, you're not still negotiating your severance by the time you get a new job. In most cases, we're typically negotiating these items within the first couple of months after you're let go. The company might come back and say, look, so and so is really marketable. There are a lot of positions like this in the market right now. We're not prepared to pay the full 12 months as a result, but we'll agree to a discount on that. We'll agree to pay 8 months. And then you're going back and forth on negotiations and trying to close at a figure that makes sense. But the point of all of this that I want to get across to you is that your duty to mitigate means that there will always be some discount on that full common law entitlement. And the way we can help you in negotiations is to highlight all the factors that will make mitigating difficult: the contracting job market, the nature of your role, the unavailability of comparable positions, and so on. It is something to be aware of, though. And so basically, if you are faced with a termination offer from the company, you don't have a contract specifying what you're going to earn on termination, or maybe you do, but you're not sure about the wording, and the amount in it looks to be more than your Canada Labor Code minimums, but you're not quite understanding what the calculation is. It is very worth, in pretty much every situation, talking to somebody to get a second opinion on that offer and to see if it is one that you should take or one that you should negotiate. Now, the last topic I want to talk about is statutorily prohibited terminations. So, up until now in this presentation, I've been talking to you about without cause terminations, which are in most cases lawful. It is allowed under Canadian law to terminate an employee without cause as long as you pay them out what they are entitled to, which could be contractual, could be common law. As long as you pay them out for those entitlements appropriately, then the termination is not unlawful per se. And sometimes in these negotiations, we are talking about, continuing benefits, continuing pension contributions, continuing various other forms of compensation through the severance period, trying to tax shelter some of that money. But typically, at the end of the day, we get to a deal that makes sense, and we're able to agree to recommend the release to you, and that's it. The file is concluded. But in some cases, companies are not allowed to terminate an employee even if it's without cause. And that is where the termination itself violates certain statutes. So, big example of this is the Canadian Human Rights Act. If you have been discriminated against in the workplace, so let's say that you asked for a disability accommodation and were denied, or you raised concerns about race or gender-based discrimination, for example, and then you were terminated just a few days later, it might be possible to raise an issue of discrimination, in which case you could be entitled to additional damages. So if that sounds like you, or if that sounds like a situation you've been through, please let us know. We'd want to talk to you about that to make sure that the final agreement isn't ignoring some of the rights that have been engaged here. Other reasons that a termination might be invalid at law is if it's in retaliation for raising health and safety concerns. So if you've been harassed in the workplace and you've been, ringing the alarm bell on that, and all of a sudden you're selected for termination, there could be issues with that. And employment standards compliance. So if you've raised issues about overtime, unpaid overtime, and then soon after that, you're selected for termination, where maybe other members of your team have not been selected, then that might be an issue worth raising as well. And there could be additional damages that you're entitled to in those situations. So essentially, just because you've been let go as part of a big restructuring doesn't necessarily mean that it's just a question of negotiating a common law package and being on your way. If any of these concerns sound like situations that you've faced or similar, then we'd like to know about it, and it would be good to get advice on what your entitlements might be. The last thing I want to talk to you about is the concept of unjust dismissal. So all these terms can be a bit confusing because we've just been talking about without cause dismissal and different kinds of terms. Unjust dismissal, those words specifically, are used to describe a complaint process under the Canada Labour Code. And it can be a pretty powerful remedy. Not everybody can apply for an unjust dismissal complaint. You have to not be a manager. You can't be laid off as a discontinuance of a function. So again, if you are part of a bona fide big group restructuring, this may not apply to you, but it still may be worth thinking about just in case it does. And you have to have at least 1 year of service. But if you are let go and you have real suspicions that it is not part of a bona fide restructuring, maybe it was timed at the same time, but it really doesn't appear that way for whatever reason. Maybe you're the only, like I said, maybe you're the only person in your team being let go, and you're being selected for termination doesn't make any business sense, and you think you're being targeted because you've raised concerns in the workplace or something like that, then the unjust dismissal complaint process allows these people who are eligible, so again, at least 1 year of service, not being a manager, etc., it allows these certain people to file complaints with the federal labor program, seeking a whole host of remedies, even including reinstatement to your job and additional damages. So if that is a situation that might apply to you, you would only have 90 days from the date of your termination to exercise this remedy. Again, I will flag and say that because this Bell Canada restructuring appears to be a general business restructuring across the board, I don't expect that the concept of unjust dismissal and the ability to complain will be present for most employees who are being let go right now. However, we never rule it out, and it is something that we'd want to canvass with you if you choose to meet with us for a consultation. So, a lot of information. To recap, You have certain baseline minimum entitlements under the Canada Labour Code that have to be paid to you, regardless of whether you sign a release or not. And so it should never be the case that you are being terminated without cause and you will be paid absolutely nothing unless you sign a release. If that's what's being told to you, then that very well might be a violation of the law. You get your minimum entitlements and then you get to negotiate the rest typically. The second takeaway is that even if your contract says something specific about what you're entitled to on termination, that wording may not be valid under current law, and you might be entitled to the much more generous protection of common law severance. You'd have to talk to a lawyer to get a good estimate of what that entitlement might be, and it might be offset, or it typically is, I should say, offset by your likelihood of getting a new comparable job within that time period. So there typically is some sort of discount on that there. However, it's usually much more generous than the initial offer that the employer is making to you. So in most, if not all cases, you're going to want to get a second opinion on that offer. Third, we look to make sure that all aspects of your compensation, or as close as possible, are being continued through the severance period. The severance period doesn't just include base pay. Typically, it's supposed to include something for benefits, pension, etc. So we want to review the offer for those items. And fourth and finally, there might be situations where you are entitled to additional damages and remedies, especially if there has been some sort of what we call bad faith, unfair treatment, discriminatory treatment, retaliation. If you have concerns about how you were treated in the workplace leading up to your termination and around the termination itself, we'd really want to know that because sometimes that can turn into additional dollars. And of course, in all of these negotiations, we are always seeking full reimbursement of your legal fees for having to go through this and contact a lawyer in the first place.